All right, welcome back. And since I think I'm going to set this to broadcast on the morning of Christmas Eve, Merry Christmas to all of you who celebrate. For those of you who don't, happy Saturday, happy weekend. um, so there was a small flurry of activity today in the De Castro versus Abrams et al. Lawsuit. And before I jump into that, though, I had a comment on my last video that I think is easier to address here than typing out a long-winded answer. So THK 184 said, basically asked, is there a good reason to continue the lawsuit given that Chile is almost certainly judgment proof? Maybe there isn't, and perhaps both both Joshes, meaning Josh Abrams and Josh Garrick, know something we don't. But I'm wondering what the end goal is. So this is all speculation on my part. For starters, we don't know for sure that Jose de Castro is judgment proof. I assume that he is, but I don't know for sure. But by the same token, both Kate Peter and Josh Abrams are almost equally judgment proof from what I know. I mean, Josh lives with his mother, which is fine, but that means he doesn't own real estate. He doesn't, I mean, I don't know what kind of income he makes from YouTube, but it isn't a lot, especially when you consider, Delete Lawz is asking for $2 million between the two of them. So, and then Kate, from what I understand, is a renter, so she doesn't own real estate. She does work full time and YouTube's, but there's like he can garnish her check, but only so much. So it's what's the point in suing them? But also, I think you look at it from Josh's perspective. Why keep suing with the counterclaims? Well, for starters, there's always the risk that you're going to lose. You shouldn't, because I believe that the claims brought by De Castro are frivolous. But there's always the chance you lose. So it's always good, if you can, to keep leverage. That this is leverage both to force a settlement, but it's also, let's say there, to go back to Depp Heard once again, you look, they both won and both lost. So, Johnny got a 10 million judgment against Heard, 10 and a third million once the punitive damages were reduced. Amber got a 2 million judgment against Johnny. That was eventually settled just this past week, with Amber agreeing to pay Johnny $1 million. So it could be, for after trial, it gives Josh leverage. It gives him leverage now. It's also, Josh may know something we don't. Remember, he was friends with De Castro before they were not friends. So it's possible that he knows that Jose De Castro is a leprechaun and has a hidden pot of gold somewhere. It would explain a lot. we don't know that. Maybe Josh knows something. But also, you've got to consider, from Josh's perspective, it might be worthwhile continuing with litigation in order to at least get into the discovery phase, because no one's provided any discovery yet. Let's just be real. And it may be worth it because he knows that non-public information could make for lucrative YouTube videos. I mean, just look at all the hubbub about what little police records Kate was able to pull based on the GHB arrest. But the court records are sealed. So forcing DeCastro to provide that in discovery, all the court records, unseal it, we'll know if he snitched or not to get the sweetheart deal. So from Josh's perspective, it could be worth the future stories in order to at least get into discovery. So those are the top things just off the top of my head. There may be other reasons. I don't know Josh. I've never spoken to Josh. I'm not a fan of Josh. But I'm even less a fan of frivolous lawsuits, which I think this is. So I hope Josh wins, not for Josh's sake, but for the law's sake. So with that, I'm going to travel back in time a little ways by way of the docket. So if you remember, on November 30th, docket number 75, Mr. Garrick filed a motion to extend the time until 21 days after the second amended complaint is filed to file an answer, which was granted. And DeCastro on December 2nd, docket number 79, filed his supplemental complaint, which presumably has been treated as the second amended complaint. So from December 2nd, add 21 days, that's December 23rd. So a response of pleading was due on December 23rd. And funny enough, the response of pleadings were filed on December 23rd. Now, Delete Lawz probably thinks this is a conspiracy and that once again, the lawyers at the 11th hour rushed out and hastily scribbled down a response and filed it in order to thwart him. Because remember when they filed their answers after he said he was dismissing, but didn't. And his whole, his argument was, well, these were clearly hastily prepared, so they shouldn't count, even though they were filed on the due date. So these were filed on the due date. And with that, let's jump right in to Kate's motion to dismiss. You'll notice this is not an answer. It's a motion to dismiss. But that's still a responsive pleading, so it counts. And assuming, if Judge Burroughs dismisses, that's the end for now, depending on whether it's with prejudice or not. If she denies the motion to dismiss, they'll have 14 days after the denial of the motion to dismiss to file their answer. So, Kate Peters' motion to dismiss the First Amended and supplemental complaints, Memorandum Incorporated. So, defendant and plaintiff in counterclaim, Kate Peter, Ms. Peter, hereby moves this court to dismiss the First Amended complaint and supplemental complaint of plaintiff and defendant in counterclaims of Jose Maria de Castro, Mr. de Castro, collectively complaint, in their entirety, with footnote 1. Following the filing of the First Amended complaint, ECF number 62, Mr. de Castro filed the supplemental complaint, ECF number 79, with leave of the court. However, the supplemental complaint does not include any counts. Ms. Peter understands that Mr. de Castro is still pursuing the count set out in the First Amended complaint, and so, for the purposes of this motion, is treating the First Amended complaint and supplemental complaint together as the operative complaint in this action. That's smart. Never assume that the judge is going to countenance the stupidity of the plaintiff, of the pro se plaintiff. So it's better to not risk it. And I should have said this at the start. It's so much easier covering when Mr. Wish and Mr. Garrick file motions. I'm able to speed through them because, yeah, I add commentary, but I don't have to look up their case citations because I'm not going in under the assumption that they're wrong citations, that they're misinterpretations, and they're even cited properly, so I can look them up if I choose. Whereas with Delete Lawz, he gets them wrong, but they're also cited wrong, so they're hard to find. So it really is nice reading well-pled motions. So, while the complaint alleges that Ms. Peter and others publish content to YouTube that largely only copies my content for monetary gain in the same YouTube content market and without my consent, a review of the at-issue videos reveals that they each reside comfortably within the borders of the fair use exception to the Copyright Act. In other words, the very videos upon which Mr. de Castro relies require dismissal of the complaint. I agree. It's an easy call. Factual background with a footnote on that header. Solely for the purposes of this motion, Ms. Peter accepts the allegations of the complaint as they were pled. So that's interesting because remember, on an answer, you have to take each allegation in the complaint and accept, deny, or explain. Deny with a reason. So here, Mr. Wish is saying, you know what? We're going to accept Delete Lawz' factual background, but only for the purposes of this motion to dismiss. So we're not accepting them in general, just for this, so that we don't have to get into it now, which is interesting. The allegations of the complaint are straightforward. Mr. de Castro alleges that Ms. Peter and others have stolen Mr. de Castro's content on YouTube regarding constitutional law and Mr. de Castro's attempts to tear down some of the racist laws in the country to profit off of that content, ECF number 62. He contends that Ms. Peter has done so in order to avoid having to create content themselves, which, fair use. She's a commentary channel. Commentary. According to Mr. de Castro, Ms. Peter and others make money from copying my content onto their YouTube channels, which are in the same market as Mr. de Castro's content. Mr. de Castro makes no allegations regarding the purported effect of Ms. Peter's copying of his content upon the potential market for Mr. de Castro's content. On the basis of these allegations, Mr. DeCastro brings a single count for copyright infringement against Ms. Peter and others. Mr. DeCastro includes in his complaint all the links containing his YouTube content and contends that Ms. Peter and others publish content to YouTube that largely only copies my content for monetary gain in the same YouTube content market and without my consent. Mr. DeCastro does not, however, identify any of Ms. Peter's content upon which he relies to contend that Ms. Peter and others have stolen his content. Exactly. He listed in Exhibit 1 of his amended complaint the URL to every single one of his YouTube videos. He made no allegations which videos of Kate's violated his copyright. There is no claim. I mean, it's that easy. There is no claim there. He has not brought into question any of Kate's videos. Review of the videos in which Ms. Peter has discussed Mr. DeCastro. I hate footnotes in the middle of sentences, but footnote 3, while materials not attached to the complaint are ordinarily excluded from consideration on a motion to dismiss, they may be consulted if their authenticity is not disputed by the parties, they are central to the plaintiff's claim, or they are sufficiently referred to in the complaint. Quoting Schaefer versus IndyMac Mortgage Services in the First Circuit from 2013. And it says, continues, Ms. Peters' videos upon which Mr. DeCastro relies are exactly such materials as they are central to Mr. DeCastro's claim and sufficiently referred to in the complaint. So, review of the videos in which Ms. Peter has discussed Mr. DeCastro reveals that in the number of videos which Ms. Peter has produced regarding Mr. DeCastro, she has only glancingly referred to his content regarding constitutional law and alleged attempts to tear down some of the racist laws in the country. So, right there, Mr. Wish is saying, look, she barely even covers his videos where he's alleging racism by the police and that we need to tear down these laws and here's what the Constitution says, because that's his market. That's his market. She barely even touches on that. She covers his antics. Ms. Peters' content regarding Mr. DeCastro relates almost exclusively to Mr. DeCastro's litigations, his alleged attempts to practice law, and his attacks on individuals. And footnote 4 includes URLs to Kate's videos. When Ms. Peter does use Mr. DeCastro's content in her own videos, she highly edits Mr. DeCastro's content to present it in a satirical and often critical manner. For example, in the video Chillism Number 1, How to Control Your Temper, with the URL embedded, such videos use brief, spliced clips of Mr. DeCastro with effects that Ms. Peter adds in editing. In other videos, Ms. Peter and others comment on and discuss Mr. DeCastro's content, discussing this case or other litigations, such as Deborah Rogers or Ironton or Yunez Lefty or so many others. On the rare occasions when Ms. Peter has made videos addressing Mr. DeCastro's discussion of the law apart from his own litigations and posted clips of Mr. DeCastro's content, she has done so in order to criticize and critique Mr. DeCastro. That's one of the prongs of fair use. Argument. Ms. Peter's content regarding Mr. DeCastro to the limited extent she has ever referred to his content about the law at all, constitutes criticism, critique, and commentary excluded from the protections of the Copyright Act by the Fair Use Doctrine. No viewer of Ms. Peters' videos could ever conclude that she was or it is seeking to pawn off Mr. DeCastro's legal analysis in order to turn a profit. No, she's giving commentary. It's obvious. The Fair Use Doctrine is a safe haven from copyright infringement. And it's congressionally created. I mean, you look at the now deleted video, but you can still find commentary on it on The Plot Hole with Johnny O, where Delete Lawz discusses it with Dr. Lawz. They think this is going to be a landmark case deciding, no, you don't have fair use protections on YouTube, even though, see the Sargon of Akkad versus Akilah Hughes case. I think it's Hughes versus Benjamin. So Akilah Hughes versus Sargon of Akkad. But so many others. It creates a privilege for others to use copyrighted material in a reasonable manner despite the lack of the owner's consent. Society of Holy Transfiguration Monastery versus Gregory, First Circuit 2012, which was quoting Weissman versus Freeman, Second Circuit 1989. The Copyright Act itself, as Section 107 establishes the fair use doctrine, which may be found when copyright work is used for criticism, comment, news reporting, teaching, scholarship, or research. 17 U.S.C. Section 107. The four fair use factors are the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. We've already gone through all four of those prongs in prior videos. A court can make a determination as to fair use before trial, so in a motion to dismiss or a motion for summary judgment, where the parties dispute only the ultimate conclusions to be drawn from the admitted facts. That's from Fitzgerald versus CBS Broadcasting Inc., from the District Court of Massachusetts in 2007, quoting Fisher versus Dees from the Ninth Circuit in 1986. That is the situation here. The videos at issue say what they say. Indeed, a motion to dismiss is appropriate where the at issue facts are derived from the complaint or the limited additional materials for motion to dismiss purposes. Citing Ville versus Poto, from the District Court of Massachusetts in 2013. So that explains why Mr. Wish has included Kate's videos that, even though Delete Lawz didn't include her videos in the allegation, so the allegation's faulty on its face, but here Mr. Wish is saying, this is the only evidence we need, is these videos. So I'm including them in my pleading so that the court can make the right decision now. Ms. Peters' videos amply satisfy the first factor, as to which courts find that the purpose and character of the use tends towards fair use where the new work adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. Yeah, Kate adds commentary. She adds criticism, critique. That's citing Commercial Bank and Trust versus Habib, District of Massachusetts 2020. And Folsom versus Marsh, from CCD Mass of 1841. Not sure what that court is, which held that holding that a work is transformative when there is real, substantial condensation of the materials and intellectual labor and judgment bestowed thereon, and not merely the facile use of the scissors or extracts of the essential parts constituting the chief value of the original work. A review of Miss Peters' videos reflects that she substantially edited, condensed, and synthesized Mr. DeCastro's work. Although the complaint does not provide sufficient allegations to characterize the nature of the copyrighted work, the second factor, Ms. Peters' videos regarding Mr. DeCastro, reflect that her focus was almost exclusively upon content other than legal commentary. In other words, the content upon which Ms. Peters did comment was not creative, but rather related to Mr. DeCastro's actions and invective. See Habib, which was already quoted above. The complaint does not make any allegations about the third factor, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Nevertheless, a review of Ms. Peters' videos reveals that this factor augurs in her favor as well. She at most uses a vanishingly small fraction of Mr. DeCastro's commentary on the law. That third factor tends against a finding of fair use when a party copies the most interesting and moving parts of a work. Harper versus Rowe, 1985, and that's a Supreme Court case. Or when more of the original is copied than necessary. Rogers versus Coons, Second Circuit, 1992. Ms. Peters neither copied the most interesting parts of Mr. DeCastro's content, nor used more than necessary. I mean, I take issue with that because most of his content is fundamentally uninteresting. It's Kate and Team Skeptic and Irish Demon and others that add interesting parts. It's their commentary that is interesting. He's the the white canvas upon which they paint an interesting video. As to the fourth factor, effect on the market, the complaint says exactly nothing about the impact upon Mr. DeCastro's market. He just says, well, they're in the same market as me, because YouTube. Under that factor, courts consider both the degree of market harm caused by the alleged infringer's actions and whether unrestricted and widespread conduct of the sort engaged in by the defendant would result in a substantially adverse impact on the potential market for the original. Once again, citing Gregory and quoting Campbell versus Acuff Rose Musica from the Supreme Court in 1994. Here, the complaint is devoid of allegations related to the purported impact on the market. In particular, the complaint does not allege, because it cannot, that Ms. Peters has usurped the market for Mr. DeCastro's work because the infringer's target audience and the nature of the infringing content is the same as the original. That is the standard set out in Carriao versus Prince from the Second Circuit in 2013, which was quoted with approval, it says, in Comerica Bank and Trust versus Habib in the District of Massachusetts in 2020. So what that's saying is Kate couldn't have usurped the market for Delete Lawz work because her target audience and the nature of her content isn't the same as the target audience for Delete Lawz. Her content is different than Delete Lawz. So even though they're both on YouTube, they are different markets. A review of Ms. Peters' videos makes clear that her audience is distinct from Mr. DeCastro's. Ms. Peter criticizes Mr. DeCastro. She does not seek to appeal to his audience. Exactly that. They're different markets. It's a different audience. At bottom, Ms. Peters' videos regarding Mr. DeCastro are exactly the species of content which is protected under the fair use carve-out. From the face of the complaint and the videos referenced therein, there is no basis to conclude that Ms. Peters' videos fall outside the ambit of the fair use doctrine. Conclusion. For the above stated reasons, Ms. Peters submits that this court should dismiss the complaint in its entirety. Respectfully submitted, Kate Peter, by her attorney, Benjamin Wish, on December 23rd of 2022. Like I said, I really enjoy reading well-pled motions. Because that was 7 pages, including the header and the certificate of service and everything. So it's closer to 5 or 5.5 pages of actual motion. But none of it is wasted. It's succinct, well-pled, says what they want, and they're done. Delete Lawz motions are double that of nothing. So now we have Joshua Abrams' motion to dismiss the first amended complaint and supplemental complaint. And he actually has separated his motion from the memorandum in support. Mr. Wish for Kate did both in the same document, but it wasn't like the ones Delete Lawz was posting and then the court clerk McManus separated them and refiled them as separate. But Mr. Wish did it all so that there wasn't like, here's the motion and then here's the memorandum where there's a clear line to cut across. It was all incorporated as one. So this is Josh's motion to dismiss. Now comes defendant Joshua Abrams, aka Accountability for All Abrams, who respectfully moves that the court dismiss the first amended complaint and supplemental complaint filed by plaintiff Jose Maria de Castro, aka Chili de Castro, aka Delete Lawz, for failure to state a claim for which relief can be granted. See Federal Rule of Civil Procedure 12b-6. Abrams requests that the court dismiss not only the sole count against Abrams in the first amended and supplemental complaints, but also that the court reject any further request for leave to amend the complaint, and that such previously pled causes of action, i.e., the defamation and intentional infliction of emotional distress causes of action, be dismissed with prejudice as well. Abrams submits herewith a memorandum of law in support of this motion and incorporates said memorandum as if fully stated herein. Respectfully submitted, Joshua N. Garrick, Esquire. So I like this. So Kate's, you'll notice, didn't mention Rule 12b-6. So it's a motion to dismiss, but it reads more like a summary judgment motion, even though it doesn't mention summary judgment either. So, but it reads as a motion for a judgment on the pleadings. Josh, on the other hand, is specifically doing a 12b6 motion to dismiss. I do like that Mr. Garrick makes reference to the defamation claims and IIED, because he wants those gone with prejudice so that they can't be refiled. We don't know what's going to come of them in the future, and probably in California. So trying to get rid of them here and now just makes sense, even though they're not current causes of action. So moving on. Ooh, it's the longest today. Joshua Abrams' memorandum of law in support of motion to dismiss the first amended complaint and supplemental complaint. Preliminary statement. Now comes defendant Joshua Abrams, aka Accountability for All, Abrams, who respectfully moves that the court dismiss the first amended complaint and supplemental complaint filed by plaintiff Jose Maria de Castro, aka Chili de Castro, aka Delete Lawz de Castro, for failure to state a claim for which relief can be granted. See Federal Rule of Civil Procedure 12b6. As currently pled, de Castro has only alleged one count against Abrams, copyright infringement, pursuant to 17 U.S.C. sections 501, etc. So basically, 501 is the definitions of the Copyright Act, and 502, 503. So given de Castro's admitted goal in this case, which is to vex, not to win, Abrams requests that the court dismiss not only the sole count against Abrams in the first amended and supplemental complaints, but also that the court reject any further request for leave to amend the complaint, and that such previously pled causes of action, i.e., defamation and intentional infliction of emotional distress, be dismissed with prejudice as well. So I like that he brings that up again. The admitted goal is to vex, not to win. And I've read a little down lower, and he does bring up the quote again, which I like. Keep bringing it up. Make the judge biased by that quote. And I'm curious because 2 days ago, in a footnote, Mr. Garrick extended the offer to Delete Lawz. If you will give you the opportunity to replead in an amended complaint, to replead the defamation cause of action, if you do it within 10 days of the forthcoming motion to dismiss. Now he's saying, just go ahead and dismiss that claim with prejudice now. And he included it here and says, and by the way, don't let him amend again. So I don't have any insight. I'm guessing there was communication in the last 2 days between Mr. Garrick and Delete Lawz, where Delete Lawz said, "You're not my daddy. You can't tell me what to do. I'm not doing what you say." And Garrick said, "All right, I'll just ask the judge to dismiss with prejudice here and now and not give you leave to amend in the future. Done." That's my guess. I don't have any insight. Procedural background. This is part of why I think this motion is longer than Kate's was. It looks like the procedural background is slightly longer. On September 2nd, 2022, DeCastro filed a lawsuit against Abrams and co-defendant Kate Peter, aka Masshole Troll Mafia Peter, alleging defamation-based claims, including defamation and intentional infliction of emotional distress. See Complaint for Defamation, ECF number 1, hereinafter referred to as the complaint. These claims purport to be predicated on statements made by Abrams and Peter on various YouTube channels during ongoing debate, commentary, criticism, and argument between the parties. On November 7th, 2022, Abrams answered DeCastro's complaint and counterclaims against DeCastro for various defamatory statements DeCastro made about Abrams on YouTube. See Joshua Abrams, aka Accountability for All's answer, jury demand, affirmative defenses, and counterclaims, ECF number 53, hereinafter referred to as Abrams counterclaims. 2 days later, DeCastro docketed a letter with the court claiming that he had intended to dismiss his complaint without prejudice. See ECF number 55. See also ECF numbers 56, 58, 59, 60, 66, 73, 80, 82, and 83, seeking similar relief. So this is the same factual background from the last motion, basically copied and pasted, at least up till now. In each instance, citing to Federal Rule of Civil Procedure 41 and recognizing that both Abrams and Peter had answered the complaint and filed counterclaims, the court could not dismiss the lawsuit without the consent of all parties. CEG, ECF number 57, 67, 74, 81, and 85. See also ECF number 64, Abrams and Peter declining to consent to dismissal. It is believed that DeCastro mightily attempted to have the defamation-based claims dismissed because he desires to refile it in California court, making it more difficult for Abrams to defend given his residency in Massachusetts. See first motion to transfer the case, ECF number 50. That request was denied, ECF number 52. As a blatant end run around the court's orders, the court said it herself. It was an end run around that decision, but it bears repeating from Mr. Garrick. As a blatant end run around the court's orders, rejecting his bid to dismiss the defamation-based claims or transferred to the Southern District of California, DeCastro chose instead to amend his complaint. On November 16th, 2022, DeCastro amended his complaint to raise allegations of copyright infringement based on Abrams' alleged unauthorized use of DeCastro's YouTube videos on his own channels. See First Amended Complaint, ECF number 62, hereinafter referred to as the FAC. The sole count in the FAC is a claim for copyright infringement pursuant to federal statute 17 U.S.C. 501, etc. See ID and footnote number 1. DeCastro also mentioned a civil RICO cause of action pursuant to 18 U.S.C. 1962, but failed to actually develop this claim in any manner whatsoever in the First Amended Complaint or Supplemental Complaint. See First Amended Complaint at paragraphs 5, 7, and 8. To the extent DeCastro believes this to be a viable claim, Abrams requests that it be dismissed as well. Once again, with very limited exceptions, it's never RICO. This not being one of those exceptions. It's not RICO. Delete Lawz did absolutely nothing to establish a RICO cause of action. It's not RICO. DeCastro then filed, with leave of court, his supplemental complaint, which purports to add YouTube, Google LLC, and John Doe's 1 through 20 as defendants. See supplemental complaint, ECF number 79. The supplemental complaint does not include any counts, and it is unclear whether DeCastro is pursuing any causes of action at all against Abrams at this juncture. Exactly. Exactly. As of now, there probably aren't outstanding claims against Josh and Kate. But it still makes sense to, until you're dismissed from the lawsuit, to treat it as if you're a defendant and keep defending the claims that might be outstanding against you, even though, as Mr. Garrick says, the supplemental complaint does not include any counts, and it is unclear whether DeCastro is pursuing any causes of action at all against Abrams or Kate Peter at this juncture. See FRCP 8A1, requiring DeCastro to plead a statement of the claim showing he is entitled to relief. Remember, we've discussed in previous videos Rule 8A, which is the standard to be pled, and Rule 8B, which is how to respond, responsive pleadings. The factual background. Assuming, without conceding, that both the first amended complaint and supplemental complaint are both operative at this point. So once again, he's saying, well, we're assuming that there are still counts alleged against Josh, but we don't agree that there are any counts against Josh. But on the off chance that there are counts against Josh, here's the factual background. Abrams will draw the facts as set forth in these pleadings. Abrams, well, that's a mistake. DeCastro, who is acting pro se in this litigation, purports to teach constitutional law. Although DeCastro does not indicate whether he is licensed to practice law in any jurisdiction, nor has he identified any law school or any other academic institution where he teaches, he purports to teach law through video content that is published on YouTube. He alleges that both Abrams and co-defendant Peter, to save from having to create content themselves, are stealing his content on a grand scale. DeCastro does not plead that Abrams is, like him, a constitutional law scholar. And so once again, that Mr. Garrick isn't expressly saying it right there, but that's saying, looky here, Judge, they're in a different market. DeCastro claims he teaches constitutional law. Abrams makes no such claim. So if the market is constitutional law scholars on YouTube, they're completely separate markets. Instead, DeCastro identifies Abrams as follows. Defendant Abrams' YouTube channel features videos of Defendant Abrams entering limited and non-public forums, libraries, child and protective support service facilities, city halls, post offices, to film employees and visitors in purposeful violation of facility policies prohibiting filming. Defendant Abrams then refuses to leave the facility when commanded, refuses to cease filming, and publishes to his monetized YouTube channel the controversial employee and visitor reactions that his filming triggers on the video, which is from the complaint at paragraph 6. Footnote 1. So that's the market that Delete Lawz claims that Abrams belongs to. It's, I belong to the constitutional law scholars and teaching market, but Abrams belongs to the First Amendment auditor market. Different markets. So you're not impacting on his market by using some of his content in your different market, right? Despite these varying purposes, as pled by DeCastro, he pleads in conclusory fashion. Everything he does is conclusory, meaning he states his conclusions. He doesn't state the reasons for those conclusions. He doesn't state the facts supporting those conclusions. He doesn't state the law supporting those conclusions. He just states conclusions. That Abrams and others copied DeCastro's content for monetary gain in the same YouTube content market without consent. He makes no allegations regarding the purported effect of Abrams' conduct on the market for DeCastro's content. DeCastro claims to have published over 800 YouTube videos on his YouTube channel. Some of these works were identified in Exhibit 1 to the First Amendment complaint. Yeah, some 800 URLs, which, I mean, he's the dumbest quarter man alive. He thinks that means, well, this means I can copyright claim everyone else who uses them because, see, they're included in this lawsuit. Ha ha. Although DeCastro boldly claims that Abrams copied and distributed DeCastro's content, no such occurrence has been identified in either the First Amendment complaint or the supplemental complaint. Exactly. Like we said with Capes. He does not say which of Josh's videos are alleged to be copyright violations. He says, Josh has violated the copyright of some portion of these 800 of my videos, but the court can guess which of his videos are infringing works and which of those 800 videos are the infringed work. The only video created by Abrams that is identified in any pleadings goes back to the now superseded original complaint. So the only video of Josh's that Delete Lawz even mentions is in support of a defamation claim. And that's, see complaint at paragraph 11, citing Delete Lawz truth. Lackluster and James Freeman join. And remember, Delete Lawz has said, I'm going to sue James Freeman and Lackluster. Their time is coming. And footnote 2, it is believed that DeCastro's complaint contains a Scrivener's error, as the YouTube link identified in that paragraph directs the reader to another unrelated video. The correct link is indicated in the text above. Of course, he can't do anything right. In this video, there appears to be only a glancing reference to DeCastro's video that was edited in a way to present it in a satirical and critical manner. This alone is insufficient to support a colorable claim for relief. So, like I said, I'm not a fan of Josh's. I don't watch his videos. So I can't actually give commentary on the amount or fashion in which it was used. So I'm trusting Mr. Garrick here. Kate's, I have watched, I think, all of her content where she talks about Delete Lawz. I can say with near 100% certainty that all of hers are fair use. But This alone is insufficient to support a colorable claim for relief. Argument. First off, the standard of review. In considering a motion to dismiss pursuant to Rule 12b-6, this court accepts only the well-pleaded facts in the operative pleading as true. Legal conclusions and those factual allegations too meager, vague, or conclusory to remove the possibility of relief from the realm of mere conjecture must be set aside, citing Star Surplus Lines Insurance Company versus Mount Air Farms Inc., First Circuit 2019, which quoted In Re Quran, First Circuit of 2017. So remember, we said in a 12b-6, the court accepts the facts pled in the complaint as true and says, if all of this is true, does it support a claim that I can grant relief for? But here, Mr. Garrick is saying, well, yeah, the court will accept facts as true, but if they're too meager, if they're vague, if they're conclusory, if they're mere conjecture, the court can't even consider them. That takes away like half the complaint. The court must then consider whether the remaining well-pleaded allegations are sufficient to support the reasonable inference that the defendant is liable for the misconduct alleged, which is also citing Star Surplus Lines, which quoted Garcia Catalan versus United States from the First Circuit in 2013. Ultimately, the plaintiff must state a claim that is plausible on its face. Ashcroft versus Iqbal. Remember, we talked about Iqbal and Twombly a couple videos ago. In addition to Gibson versus Conley, or Conley versus Gibson from 1953, as the Supreme Court cases on the pleading standards for a Rule 12b-6 motion. Stating a plausible claim requires more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not suffice, citing Bell Atlantic versus Twombly. Conclusory allegations that merely parrot the relevant legal standards are disregarded, as they are not entitled to the presumption of truth, citing Manning versus Boston Medical Control Corp., First Circuit 2013. See also Iqbal. A court reviewing the plausibility of a claim may disregard allegations that amount to mere legal conclusions, which are not entitled to the assumption of truth. Under this standard, De Castro's claims must be dismissed. De Castro failed to plead a viable copyright infringement claim. I agree with that header. To establish copyright infringement under the Copyright Act, De Castro must prove two elements: ownership of a valid copyright and copying of constituent elements of the work that are original, citing Lotus Development Corp. Versus Borland International, First Circuit, 1995. Affirmed by the Supreme Court in 1996. And quoting Feist Publications, Inc. versus Rural Telephone Service Company, 1991. Supreme Court as well. De Castro has failed to meet this burden in both respects. De Castro has failed to plead an ownership interest in the works he claims is copyrighted. Ordinarily, ownership vests in the author if he can prove the work is original and he complied with statutory formalities, citing Society of Holy Transfiguration Monastery, Inc. versus Gregory, First Circuit 2012. Indeed, an author can establish prima facie ownership of his works if he obtains a certificate of copyright registration. Save for registration, it is De Castro's burden to prove exclusive ownership of his works. De Castro has not pled in the First Amended or supplemental complaint that his works are registered. He has also failed to plead that he has exclusive rights to these materials. And this is for good reason. De Castro has granted Abrams, among others, a license to use his works that are posted to his YouTube channels. This is going to be good here. But so before we get to a license, remember, we've discussed copyright law, and you need, so the minute I finish this video and I hit end recording, it's fixed in a tangible medium. I own the copyright to this video. But let's say Delete Lawz goes ahead and posts this video in its entirety with no commentary, no editing, just this video on his channel. In order for me to sue for copyright infringement, I have to obtain a copyright certificate from the United States Copyright Office before I sue. And it's not an application for that copyright certificate is insufficient. You need the certificate granted. That takes a long time, although you can pay extra to expedite it, which results in it taking a couple of weeks instead of a couple months. Delete Lawz, last I checked, which was when I covered the copyright standards, does not have any copyright registrations, no certificates. Yes, he owns the copyright to his videos. He does not have any registrations, period. This lawsuit, this claim for copyright infringement, fails on its face for that reason. I mean, if it's dismissed without prejudice, he could maybe bring it again and then lose on the merits, but he has not pled sufficient facts. And because one of those facts needs to be, I have registered my copyright with the U.S. Copyright Office. Here's my certificate. So, as to the license, as contained in YouTube's terms of service, rights you grant. You retain ownership rights in your content. However, we do require you to grant certain rights to YouTube and other users of the service as described below. License to YouTube. By providing content to the service, you grant to YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it in connection with the service and YouTube's and its successors and affiliates' business, including for the purpose of promoting and redistributing part or all of the service. The license to other users. In YouTube's terms of service, you also grant each other user of the service. So you grant, by posting this video on YouTube, you grant to each and every other user of YouTube a worldwide, non-exclusive, royalty-free license to access your content through the service and to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it, only as enabled by a feature of the service, such as video playback or embeds. For clarity, this license does not grant any rights or permissions for a user to make use of your content independent of the service. So, what does that mean? It means by posting his videos on YouTube, Delete Lawz said, hey, other users of YouTube, you can use this video in fair use, of course, but you can use this in other videos on YouTube, which has been done. He agreed to the terms of service in order to create his account. He in essence, when he created his YouTube account, granted a license for Josh and Kate and me and everyone else on YouTube to use his videos to a certain extent. And that's from the YouTube Terms of Service, January 5th, 2022. And see also Biz Casual Holdings versus YouTube from the Southern District of New York in March of 2022. With footnote 3, the court may consider YouTube's terms of service in adjudicating this motion to dismiss. See Force versus Facebook, Second Circuit, 2019. Appeal from an order granting a motion to dismiss, explaining that Facebook's publicly available terms of service are subject to judicial notice, citing the Federal Rules of Evidence 201(b)(2). Moreover, the terms of service may be considered because they are integral to the complaint. Shandong Shinho Food Industries versus Mayflower International from the Eastern District of New York, 2021, case alleging trademark infringement, considering a license to the trademark on a motion to dismiss because the license was integral to the complaint. So here, the footnote says, look, Judge, you're allowed to consider YouTube's terms of service in order to decide this motion. And I bet you should. By granting users like Abrams the royalty-free right to use and reproduce his materials, DeCastro has failed, as a matter of law, to establish ownership in the work he lists. See Estate of Hevia versus Portrio Corp. First Circuit, 2010. Use of copyrighted work within the bounds of a license do not infringe on the copyright. DeCastro's claims also fail because he has not identified in either the first amended complaint or the supplemental complaint any such copyrighted material that Abrams purportedly stole. Once again, he hasn't made mention of Josh's videos. While DeCastro lists several works he claims to be his own, he does not once cite to any of Abrams' materials that allegedly used DeCastro's copyrighted works. Instead, in a conclusory fashion, bring that up again, keep saying it's conclusory, DeCastro merely states that Abrams published DeCastro's content for monetary gain. This is insufficient to survive a motion to dismiss under the well-established Iqbal-Twombly standard. Having failed to articulate any such works, DeCastro's copyright infringement claims necessarily fail as a matter of law. Also, DeCastro's claims are barred by the fair use doctrine. The fair use doctrine is a safe haven from copyright infringement. it creates a privilege for others to use copyrighted material in a reasonable manner despite the lack of the owner's consent. Once again, citing Gregory, which was quoting Weissman versus Freeman. The fair use doctrine states the fair use of a copyrighted work for purposes such as criticism, comment, news reporting, teaching, scholarship, or research is not an infringement of copyright. See 17 U.S.C. Section 107. While Abrams and the court is left to guess what works DeCastro believes have been improperly used by him in violation of DeCastro's copyright work rights. To the extent Abrams has ever referred to DeCastro's content at all, it constituted criticism, critique, and commentary that is excluded from the protections of the Copyright Act by the Fair Use Doctrine. I like that. We have to guess what DeCastro is even referring to. But anything he might be referring to is fair use anyway. While the First Amended complaint and supplemental complaint do not identify any such unauthorized use of DeCastro's work, the sole video referenced in this litigation, albeit in the now defunct original complaint, the defamation, is an edited 30-second clip where DeCastro essentially states that he is an undesirable person and a criminal, murder, rapist, child molester, drug addict, alcoholic, animal torturer, worst person ever, etc. This 30-second segment was used by Abrams as part of an hour-and-a-half-long commentary and criticism of DeCastro. It was not used to teach constitutional law or to compete with DeCastro. Different market. It was used to criticize him. DeCastro is not in the market of DeCastro criticism. In fact, he very much frowns upon that entire market. This is textbook fair use. Peter, in her motion to dismiss, goes through the 4 statutory factors. There's been collaboration between Mr. Garrick and Mr. Wish. Peter goes through the 4 statutory factors a court can consider in conducting a fair use analysis in closer calls. While this analysis is unnecessary given the clear fair use of Abrams in the sole video identified by DeCastro in this litigation, Abrams adopts and incorporates the case law and logic cited by Peter in her motion. Yes, hey, Judge, if you haven't already read Peter's motion, which is, by the way, number 94 in the docket, our motion was number 95, and this memorandum in support is 96, so you hopefully have already read it. Go read that, and we concur. So Abrams adopts and incorporates the case law and logic cited by Peter in her motion. See ECF number 94. Vitally, where DeCastro complains, I bet they even collaborated to the point where Mr. Garrick said, hey, Benjamin Wish, why don't you file first? Because I'm citing to you, to your motion in mine. So it makes it easier if you file it as ECF 94 so that my citation makes sense. Vitally, where DeCastro complains about a truncated 30-second clip out of DeCastro's library of over 800 YouTube videos, most of them rambling, that does not talk about constitutional law, but instead is relevant to Abrams' hour-and-a-half-long debate, commentary, and criticism of DeCastro, and where there is nothing in the pleadings whatsoever about market value of DeCastro's work, there's very little market value to his work, it is clear that Abrams is not infringing on any copyrights owned by DeCastro, and any such publication is protected by the fair use doctrine. Footnote number 4, to the extent DeCastro's complaint could be read to discuss other potential copyright violations, Abrams is without sufficient knowledge to determine what those violations are, and he declines to guess. Nevertheless, to the extent DeCastro identifies any other videos used by Abrams, it is likely that the use was similarly protected by fair use doctrine. So what this here is saying is Delete Lawz might be alleging there's other copyright violations, but I'm not going to guess what they are. And besides which, Judge Burroughs, it would be a due process violation to expect us to guess and defend those guesses, because due process demands that we be put on notice in the pleadings what we're defending against. And how many times have we heard Delete Lawz say, due process of law says this, wrongly. Due process of law says that, wrongly. This, Mr. Garrick doesn't say due process, but footnote 4 is clearly a due process argument. Where was I? Accordingly, the copyright claim fails as a matter of law and must be dismissed. Furthermore, the civil RICO cause of action should be dismissed. I would laugh if this entire section was, it's never RICO. Done. DeCastro referenced a civil RICO cause of action in the first amended complaint, but it is unclear what facts he uses to support this claim. Indeed, none of the requisite elements necessary to plead a colorable civil RICO cause of action are articulated in either the first amended complaint or the supplemental complaint. Accordingly, the civil RICO cause of action should also be dismissed with prejudice. We discussed a couple videos ago why it's never RICO. The court should decline leave to allow DeCastro to amend his complaint for a fourth time. So, just looking ahead, he brings up that quote again, which I like. And I wonder, because I haven't read all of this, I wonder if he makes mention of the offer to amend, to reincorporate the defamation cause of action again. That was in the motion 2 days ago. DeCastro has now filed an original complaint, the first amended complaint, and the supplemental complaint in this action. And remember, there's an email before the first amended complaint. I can't remember if it's from Mr. Garrick or Mr. Wish, where they said, "Well, we know you're going to file an amended complaint. Please file it, and then we'll answer that." And Delete Lawz responded, "No, you're playing my game. You have to respond, and then I'll file an amended complaint, because you're not my daddy." So, and then completely changed the cause of action. So they responded to something that he wasn't even pleading anymore, which can reasonably be assumed to be a ploy to cost them money by having to defend two different causes of action instead of just filing an answer. He should not be granted leave to amend for a fourth time in a way that could potentially save any of his claims. This is because DeCastro has used this lawsuit in a perverse manner, seeking not to win on the merits, but to instead vex the defendants. There's that word again, vex. DeCastro has brazenly admitted to these ulterior motives. I will break Peter and Abrams financially. They will have to hire a lawyer. I will file motion after motion and I'll just keep going legally after them until I break them, until they can't afford to hire a lawyer anymore, so they run out of money. That's what I'm going to do. I'm going to break them. Which is a quote from ECF number 71, which was the motion for contempt against Delete Lawz. But it's a direct quote from one of his videos. Here, where DeCastro has already been given leave to amend twice before, the fourth bite at the apple only serves to further DeCastro's vexatious motives. See City of Mia, I assume that's Miami, firefighters and police officers Retirement Trust versus CVS Health Corporation, First Circuit 2022, affirming denial of leave to amend when plaintiffs sought a third bite at the apple in the form of a second amended complaint, and Aponte Torres versus University of Puerto Rico, First Circuit 2006, serial amendments may be given closer scrutiny because busy trial courts, in the responsible exercise of their case management functions, may refuse to allow plaintiffs an endless number of trips to the well. So basically, Mr. Garrick's brought case law saying, look, it's a heavy burden for us to have to defend multiple changing complaints, never knowing what we're defending and having to pay a lot of money to do so. But it's also a waste of the court's time. Similarly, in ruling on the motion to dismiss, Abrams asks this court to dismiss all claims, including the defamation-based claims in the original complaint that have seemingly been abandoned with prejudice. Abrams is wary that DeCastro has abandoned these claims intentionally so that he could do an end run around this court's orders, declining to accept his belatedly filed notice of voluntary dismissal of the defamation-based claims. Abrams' concern is that DeCastro may refile the defamation cause of action in a California court, a venue that lacks personal jurisdiction over Abrams, a Massachusetts resident with insufficient ties to California. I mean, even if it is dismissed with prejudice, my guess is Delete Lawz refiles it anyway. And, he makes minor changes, but it's still the same operative suit and says, well, he defamed me here instead. But it's like, no, you had to bring that all in the same case. The California court should nonetheless dismiss such a refiled claim, not only for lack of personal jurisdiction, but under the doctrine against claim splitting, which precludes a litigant from strategically pursuing a subsequent suit claims, from strategically pursuing in a subsequent suit claims which were or could have been brought against the original defendant in the original suit, citing Airframe Systems versus Raytheon, First Circuit 2010, also Mendoza versus Amalgamated Transit Union International, Ninth Circuit 2022. So we discussed claim splitting in the last video, but that also applies any alleged defamatory claims or even copyright infringements that had been made at the time the suit was filed. If he loses this suit and then says, oh, well, I'm going to sue on this other copyrighted, this other defamatory statement, that's claim splitting as well, because it should have been brought in this suit. Subject to reversing his rights to challenge an amendment on the merits, Abrams will agree to give DeCastro one final chance to replead the defamation-based causes of action in a third amended complaint with Abrams' assent, so long as it is filed within 10 days of receiving this motion. With footnote 5 saying, the 10 days will likely have elapsed by the time DeCastro files an opposition to this motion. Should DeCastro decline the invitation, Abrams asks this court to rule that all claims raised in the original complaint are dismissed with prejudice and reject any further attempts by DeCastro to amend the complaint as futile, unduly prejudicial, in bad faith, and in furtherance of DeCastro's documented dilatory motives, citing Foreman versus Davis, Supreme Court, 1962. So he actually hasn't rescinded that offer. Like I said, I didn't read ahead. So it's, please dismiss all these claims, but we'll let him replete it just so that it's officially in front of you, and then we'll ask you to dismiss it with prejudice as well. Conclusion. For the reasons stated herein, the court should dismiss all claims that were or could have been raised in the original complaint, the first amended complaint, and the supplemental complaint, including the copyright infringement claim, the civil RICO claim, and all defamation-based claims with prejudice and without leave to amend. Respectfully submitted, Joshua Garrick, Esquire. Well, that was a mouthful. That was an excellent motion. Like I said, it's a joy to read, well-pled, well-written motions. There's the obvious occasional typo or, putting DeCastro instead of Abrams or vice versa, but I'm not criticizing because I do the same thing. But it's so much easier to read and discuss these motions than those filed by Delete Lawz. But with that, please give me a Christmas present. Like, subscribe, share, all the fun YouTube-y stuff. And with that, once again, thanks for joining me. Merry Christmas. I hope you're able to stay warm. I know it's cold throughout most of the U.S. Stay warm, stay safe, have a great holiday, and I will see you soon. Bye-bye.